Welcome back to the channel. Today's case features a familiar face stepping into court once again, attempting to challenge the charges with a self-prepared motion and a very questionable understanding of the law. Let's take a closer look at how this unfolds.
What is your date of birth, Mr. Gray?
Good afternoon, Your Honor. 72 is my date of birth. I have a...
Can you say that again? Go ahead and say what you were about to say.
I have a motion before the court, Your Honor.
Let me first start. Do you need a lawyer, sir?
No, Your Honor.
City of Detroit versus Christopher Gray. State your name for the record, please.
Christopher Lamar Gray.
All right, today is the date and time set for a pretrial, and then there's warrants on the other matters. I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond, and I'll recall the warrants. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. You want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else do you have to say? What else?
You deny my motion because of what, Your Honor?
The court makes it clear that the argument is fundamentally flawed, noting that the defendant's position reflects a serious misunderstanding of the law. The judge points out that avoiding a full reading of the charges only sidesteps a critical issue, namely, the improper reliance on federal civil procedure rules in what is clearly a criminal matter. Based on that reasoning, the motion is denied.
There is no real...
I denied your motion because there is a, and this is criminal procedure, not civil procedure. But I denied your motion because there is an allegation here.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delicti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened, someone has either been damaged or someone has been or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person, and if I hurt this person and I created the crime, then you are the third thing that you have to have is the identification of the person. You have the identification of the person, which is me, but you don't have a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay. You went to law school?
No, Your Honor, I have not.
Shows.
And where did you get that from? Where did you learn all that?
I've been studying for quite some time, trying to understand what's going on. I have a different perspective as to what's being said that happened. I'm understanding more the procedure that is necessary for a crime to go for them to bring a crime forward. I'm understanding that a bit more.
The judge steps in to correct the misunderstanding, explaining that simply repeating legal terms isn't the same as understanding them, especially when it comes to corpus delicti. The court clarifies that this concept does not require a victim to be physically harmed for a crime to exist. Instead, it means the prosecution must first establish that a crime actually occurred before securing a conviction. The judge goes on to draw an important distinction. Probable cause, which supports the filing of charges, can be based on documents and an officer's account. However, corpus delicti requires a higher level of support, such as witness testimony or tangible evidence, to confirm that an offense took place. From there, the burden remains on the state to prove the case in full during trial.
And where did you get that understanding?
I've done some Cornell law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law. I just started to go back through Cornell law, started to figure out what was going on and to understand the nature of how crimes, what a crime is, and everything else. So just a course of me searching it out.
And you're citing Cornell law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is you have to have the corpus delicti. And that is in when you're being charged criminally.
What is a corpus delicti?
What do you mean, what is the corpus delicti?
What is your understanding of what corpus delicti is?
That is the corpus delicti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delicti, which is you saying this is what happened. This is how this person was damaged.
So
there is no
the
person.
Officer on these dates, because I got a lot of them, said that
I object. I object. The officer works.
Don't interrupt me.
I apologize, Your Honor. I apologize, Your Honor. My apologies.
The officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in the state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talk about, corpus delicti and things like that, the court denies the motion, okay? Based on those reasons I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My apologies, Your Honor.
How do you want to move forward? Because in my experience, someone that comes into court, as you do, you do not want to take an offer. You do not believe that you need to have plates or registration or insurance, and you just disregard all of that portion of the law. And either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to put my objection on the record.
The judge presses for clarity, asking the defendant to specify the basis of the objection. The court explains that the issue at hand is straightforward. The defendant must decide whether to proceed to trial or explore a resolution with the prosecutor. The judge then encourages a clear and direct response so the case can move forward without further confusion.
And at that point,
whatever your objection is noted. What do you want to do, sir? Do you want a trial? You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Very good. Ms. Mathis, I need a jury trial date. Please.
And if I may, Your Honor, what time is Mr. Gray presently docketed?
I don't even think it matters, but I'll tell you. I don't think it matters. He's got the newer cases and the older cases are pre-trial at 8:35. Christopher Lamar Gray and then he had some in warrant status. I counted 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases into the record. You know what I want to ask Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been, the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well then that's fine. If we're following rules, then therefore let me make sure that you as well as are following the rules, because if I don't do that, then freedoms are lost. So that is in which, that is the way that I proceed, to say, okay, well then if we're playing cards and we playing show me yours, if this is your hand, then this is mine, and let's proceed accordingly to the law. That's it. That's my only standing, is if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
And you know something? With that
Yes,
being said, I would agree with you 1,000%. That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here, and the police for that matter, and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench, and in my time at practicing law as a defense attorney, I get this, they can't pull me over. I've heard the corpus delicti, first time the civil procedure has been thrown at me. But from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have again, Your Honor, what I feel is that if we are following rules, that if I have to follow the rules, and every person out there, all of these officers, everybody else has to follow the rules. So if it comes down to it,
what I'm gonna hope that you do by the time you come back on the trial date, jury trial date is gonna be March the 18th, 2025.
Thank you, Your Honor.
You're probably gonna have an audience, because everybody follows me on these cases all the time.
I understand.
The narrator adds a light, supportive note, expressing appreciation for the judge while pointing out one limitation. These jury proceedings typically aren't publicly streamed. With that in mind, they make a polite request. If possible, consider allowing this trial to be accessible to a wider audience.
All right, and I don't know if that's what you want, but we're gonna do that.
It's not that.
March the 18th, 2025. We're gonna have a final pre-trial date. Final pre-trial. This is to you, Mr. Bowman, especially the day before, on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. and the trial is going to be in person. All right? All parties must appear on final pretrial date and obviously on the trial date. And what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say, I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and so yeah, I guess it's to the table we go. So
yeah, but get your game in order, because I'm just giving you a little heads up. If you come in with that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors, or even all of them, to have some sympathy for you, sir.
I got a whole basis for understanding, and so yeah, if you know it.
Well, that basis that you outlined shortly today is not.
What was flawed in my what was flawed, Your Honor?
The judge delivers a firm assessment, explaining that the defendant's statements reflect a fundamental misunderstanding of the legal framework. The court notes the improper reliance on federal civil procedure in what is clearly a statutory criminal case, along with a continued misinterpretation of corpus delicti. The judge also points out that this legal standard has already been satisfied based on the evidence presented so far. Given these issues, the court strongly advises the defendant to seek legal representation, emphasizing that counsel can be appointed at no cost if needed, as guaranteed under constitutional rights.
We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delicti, they do have a corpus delicti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay. All right. Okay. Well, I guess we will have that discussion again. I appreciate it. I also want to say I recognize and honor your compassion that you sit on the bench with. I see it as you go out here and you judge our people, and so for all of that, kudos, man. That's for where you sit. I appreciate that. Thank you, sir. Appreciate it.
I appreciate
that.
Sir. Mr. Gray,
yes, sir.
You have a safe happy holiday season, sir. And
you as well.
Best of luck to you. I'll see you back on March the 17th, 2025 at 8:30 for a final pretrial. And let me say this, let me add to the record.
Yes, Your Honor.
If there's any motions, those motions need to be in writing.
10 days within 10 days.
Let's put that on the record too, a motion date. Those motions need to be in writing. Have those motions to the court by February 14th, 2025. And the response will be February 21st, 2025, and I'll rule on those motions on the final pretrial date of 3/17/2025. Again, all parties must appear, Mr. Baldwin.
The court reiterates that this issue has already been addressed. The judge explains that relying on the federal rules of civil procedure for a motion to dismiss is not appropriate in this type of criminal case. Turning to corpus delicti, the court makes it clear that the legal threshold has been met and the charges are properly supported under the applicable state statutes. The relevant statute numbers, the judge notes, are listed directly on the citations, making the legal basis easy to verify. The judge emphasizes that this process operates under a specific set of rules, and it's important for the defendant to understand the framework moving forward. The matter will be revisited, but for now, the court acknowledges the defendant's remarks and proceeds to scheduling. The next hearing is set for March 17, 2025, at 8:30 a.m. for a final pretrial conference. Any motions must be submitted in writing within 10 days, with a filing deadline of February 14, 2025. Responses are due by February 21, 2025, and the court will address all pending motions during the scheduled hearing. With that, the case pauses until the next court date. On the commentary side, there's anticipation building for what's to come, along with a hopeful note that the upcoming proceedings might be made available for public viewing. If you found this breakdown helpful, be sure to share your thoughts and stay tuned for future updates.